Have a legal question for a Talking Law TV attorney? We offer 3 ways to ask it. Call 888-2037-LAW for our free viewer phone line. Email your question through the website at talkinglawtv.com or text your message to Talking Law TV. Get a link sent to your mobile phone by texting TLTV SAV to 82672. It's legal news you can use when you need it, anytime and any place.
And welcome back to more Talking Law TV. We're here with a special treat at some of our viewer mail from the website and the toll-free number. We're here with Doug and Christy. Hi.
Hey.
Thank you both for coming here to answer some of our viewer mail. Our first one is from Tim, who says, Dear Talking Law TV, you guys are the best. Thanks for being there. Here's my question. How do I get my deadbeat boyfriend to move out? He's lived here 14 months, drinks more than he works. We argue more than we talk, and he says he has nowhere to go. I want him out. What do I do?
Oh, boy.
I would suggest that you just tell him, it's over. It's best if you just get out, period. I'm on the lease, you're not. And see if you can bluff your way through it. He doesn't have to go. Depend upon the status of the relationship. I assume he's not a tenant of yours, so that he is at worst a licensee, and if you take his license to be there away, he should just depart. But in theory, he could be a tenant at sufferance. You might have to give him notice. You may have to go get him evicted by the magistrate court. So it can get ugly.
So if you call the police and say, make him leave, did the officers know tenant at suffrage?
No, I had a case recently. I got the call the next day after the incident happened. The police says, no, you have to go to magistrate court and get him evicted. They wouldn't make him leave.
Often they don't want to get involved and determine the facts and make the decision, so they just tell you to go let the judge hear it.
Okay, so Tim, you're good for 30 more days, buddy.
Lesson learned. Be careful who you let into your house.
Let's start looking for number 2. Okay, our next one is from Darla, who was arrested for DUI, and the officer never read me my Miranda rights, but I did all the tests he wanted. Was that legal?
You know, most people grow up learning the law from their TV sets. Unfortunately, some of them are from Car 54, Where Are You? Before some of our viewers' time. Bottom line is, and I get this a lot, the police do not have to read Miranda unless they have placed you in custody, arrested you, and they then want to interrogate you. In your garden variety DUI case, they've already interrogated you prior to the arrest. They ask you all those questions. Have you been drinking? How much have you drank? And so forth. They ask all those questions before they cuff you, before they arrest you. Once that happens, they're done asking questions except for the one biggie, reading implied consent, asking you to take the test. Of course, you can decline. You don't have to answer them, but just because they don't read Miranda, they rarely do. However, if you're riding to the station and they haven't read Miranda and you're riding in the back seat of the car chatting with the officer and you volunteer some information, you robbed a bank last week, they may have some trouble getting that into evidence unless they can show it's a spontaneous, excited utterance or spontaneous explanation. So I teach officers it's best to read Miranda because everybody expects it, but you don't have to.
Maybe Darla can call Tim and get a ride. Okay, our next one then is from Sam. I got laid off and had to find another job making much less than I was. I cannot afford to pay the same child support and cannot afford an attorney. The child support office doesn't seem to care. How can I avoid jail, losing my license that I need to drive for work, or being labeled a deadbeat dad with thousands of dollars in arrears stacked on me? And coincidentally enough, this morning I saw one on the morning show and $31,000.
Well, it adds up fast. Bottom line is that order for child support is going to stand until he gets it changed. So he's got to figure out a way, and there are new laws now that try to quickly get that support reduced, but he's got to get it within the court system to do it.
And most of our judges are wary about reducing it too soon because they figure, well, you got to get a job if you don't have one at all, and things will get better. So they don't like to reduce it right away. They like to say, well, what's your 12-month past average? And then folks will say, well, I don't have money to hire a lawyer. What do I do? There are some websites out there. Just type in Georgia Child Support Form Modification, and you'll find a website that will give you some forms, because child support is helping the parent that's getting the child support, so they're not going to help you get it reduced. Although, in my view, they ought to provide that service, because it's a matter that's best for the family. If somebody is not legitimately making the same money, everybody needs to tighten their belts. That's what they do if they were together, so they need to do it even if they're separated. And it doesn't help for dad to lose his driver's license or go to jail because he can't pay the amount. So that's the time to make common sense prevail.
Yeah, you would think with what judges make, they could afford a newspaper subscription. And for me, find out what the job situation is out there for these people.
Right, but I think there have been occasions where the non-custodial parent who's paying child support, you know, electively takes a cut in pay or takes a job where he's being paid under the table, and so I think, you know, the bottom line is the child has got to eat, whether you're working or not. But they're real skeptical about, oh, you know, I lost my job, and that you can still afford your brand new car. So you just have to look at each case and see if it's a legitimate reason, then you probably do have a good chance. But doing nothing, that order stands, and that arrearage is building, it's snowballing.
How long does the modification process take if you're successful?
That depends upon the court, how quickly they can get it in, you know, that depends.
The fastest is going to be about 3 months, the fastest. And sometimes if it's just clear on space, you might get a temporary order sometimes. But usually 6 months to 12 months, you're still arguing about, because the other side has a right to do discovery, take depositions, get your pay records, so they can drag it out for discovery periods. So you're hurting.
So get it started. The sooner you get it started, the quicker it'll be resolved.
Okay. The next one's from Tasha, who said, I did something stupid. I shoplifted some stuff and got caught. I'm a licensed professional, and I don't want to lose my professional license. Do I have to fight the case even though I'm guilty? I'm told it's all on video. What should I do?
Well, I've had a couple of those cases, and there are licenses. If you have a license, and it's probably under the purview of the Secretary of State, because there's about 50, that's an estimate, 50 different things, from cosmetologists to teachers to whatever. And if you commit an offense that is integrity related, like shoplifting, they can pull your license. And they can do that even if you're found not guilty. They can do it if you get First Offender Act. So you need to get some competent legal advice before you make any decisions. And yeah, confession is good for the soul, but not when you're in the back office at J.C. Penney's being grilled by the store security. Don't know if you're under pressure and just complying with them so you can get out of there and signing whatever they put in front of you. Think twice about what you're doing. First of all, don't shoplift if you like your occupation. But secondly, if you did something stupid, then don't make it worse, and get some competent advice, because this is America. You have the right to counsel in all of those types of cases.
So speaking of that, if you're taken in the back room by JCPenney or another merchant, not picking on JCPenney, but they're not a sponsor anyway, so you don't really care. But do they have the right to hold you in that back room, or do they need to call the police, or can you just get up and leave, or is that kidnapping?
They have usually called the police at the time. Somebody's already called the police when they're asking you to step to the back, but they like you to sign a paper acknowledging your guilt. And they often are, with all love and affection, wannabe cops. They're not police officers, but they maybe want to be someday, or they couldn't pass a muster and they'll never be. But either way, they do get rather arrogant and bullying of people and have them in tears, and they'll sign anything.
Okay. Well, thank you, Doug. Thank you, Christie, for answering viewer mail. If you have a question you'd like to answer here on Talking Law TV, or have the lawyers email you directly, you can contact us through the website at TalkingLawTV.com, or call our toll-free number at 888-203-7LAW, that's 529, and we'll join you again next week right here on Talking Law TV. Bye-bye.
Closed captioning services provided by the Web Advantage. Design, hosting, and multimedia solutions for businesses like yours. Produced by Tandem Productions. Distributed by Legal Eagle USA.